Regarding you were discussing about compulsory licensing. Basically under section 24, what I mean to ask is like, do we have a provision that, because when we look at a patent draft, actually what these companies are doing is they are actually telling a particular drug or has to be manufactured under the temperature condition ranging from 18 to 90 degrees Celsius or whatever like that. So it's very ambiguous and it's not specific at all. So when we say a particular the patent is being compulsorily licensed to say small scale industry or something like that, so is it enforced on the particular inventor to even disclose the actual mode of preparation and not the vague ranges as such? This is my short question.
Yeah, in theory, yes, you are supposed to disclose your mode of manufacture.
But that never happens. They never tell you. So how do we deal with that?
You can't do much about it. You can fight about it. But you, by and large, you see, once many of this thing you can work out in the laboratory. If you are a skilled manufacturer, once you know the broad process, like we were doing re-engineering, reverse engineering.
So, but then that would take another years of like.
Yeah, but I ought to simultaneously start working in the laboratory while I'm filing the compulsory license. Yeah, it will prolong.
Because the moment we say a compulsory license is required, that means firstly it's an emergency, that because there is an epidemic, and we say, look, you are not preparing the medicine properly, or maybe you are not making it available to the public. So it has to be readily available so that people can use it right now.
Yeah, but so it never can be readily available. Compulsory license means even the best of people take 1 year.
Yeah.
1 or 2 years.
Yeah.
So it's never readily available. Like Tamiflu and all this.
Yeah. So what my question was, can it be enforced on the inventor to actually disclose the actual process? How they are?
He's supposed to. In fact, disclosing specifications. You have worked as a lawyer. Yeah. The specification they say they're supposed to give all these
ranges.
Okay. They won't give you minor details, trade secrets. Yeah. They'll all hide that. Even in routine manufacturers, some trade secrets, but not trades. Yeah, it's not given in any pharmacopoeia. But you know only by practice. You have to live with it. You can't do much. You can push them and say, no, this is what we have, etc. But again, the case law has to be fought on that. Nobody has fought on this issue. How much we'll succeed, we don't know. But my guess is that it's not worth fighting. It's doing your own re-engineering and rediscovery and so on.
Sir, you have when you were talking about border exceptions, you said that if patent will expire in 2020, then others start their preparation from 2018 because they know that in 2020 the patent is going to be expired, right? So I just want to inquire you that how come everybody knows in the competition that the patent is going to expire in so and so date or so and so year? Is there any chart or something like that?
Oh yes, because see, every patent is supposed to be disclosed in public, so it's supposed to be published. If you go through the website of the patents controller, all the details are given. So which drug is given, what patent is, when was it filed, when was it awarded patent, and when is it going to expire. So that's available.
Okay. And sir, one thing more I want to know, that in your slide I have seen that you were talking, it was written that pre-grant and post-grant both oppositions are relished, right? So sir, pre-grant opposition we can understand, but after patent how can we do a post-grant opposition?
Post-grant, you see, well that's a novelty, because you see, what, like I suppose I missed the pre-grant because something I didn't know that it was being filed, etc. Suppose I missed it. That's one possibility. The other possibility. Then, what is my chance? And I found that some new fact came after the patent was granted, that there is already a prior art. There's already something somebody had made this, and therefore it is not an obvious thing. It should not have been given. But because the facts were not disclosed, but this fact came to my knowledge as a challenger. So after the patent was awarded, I had to wait for 3 years. Because after 3 years, once the award is paid, only you can do the post-grant opposition. Then I put these facts as post-grant opposition. And in this case of regulated interferon, what had happened was in the pre-grant they failed. Our challenges failed. So the patents controller said it should be given patent. There is no question of it. So it went ahead and gave the patent. But these fellows said, waited for 3 years. And one of the question of cost, but especially they discovered some new facts. Why pegylation was an obvious thing. So because it was pegylation of interferon is an obvious thing, and they tried out, they argued with new facts in the court. And they said yes. So their patent was revoked. So the contradiction is sometimes it is the same patent's office. The left hand gives the patent, the right hand revokes it, or vice versa. So, and that's it, but a contradiction. That's how it is.
So I had a question. We have gone ahead and discussed this particular side of medicinal or medical system, but there are other emerging medical systems. So I'll take it a little back to the previous session. What are the price control mechanism, if any, available for other medicinal systems, which is there in India and as well as in, they must be emerging in other countries, other South Asian countries.
I don't know about other countries. In India, we have no price control. Not allopathic system. It should be there. But Ayurvedic medicine is selling at very high prices. That's something, somebody has to take it out, lobby for it, make an issue of it. Then it'll come.
What are the challenges in getting a patent for that? Because many of these Ayurvedic or other such processes and products are so much pre-existing in our society. So how do we tackle it?
No traditional knowledge can be patented. Traditional knowledge, and within India, so there won't be any patents on Ayurvedic system. But internationally, somebody can, in neem ke upar hota hai, or methi seeds and so on. So what to do that? You have to challenge in, say, California. California when neem was given. So what do? I have to show that a turmeric, that medicinal properties, antibiotic properties of turmeric, is given a patent in this. But you have to challenge that. You can't challenge in India because it's patent award in the US. So I have to produce documents. How can I produce it? It's traditional knowledge is there. It's only. My grandmother used to do this. You can't say that. No? That won't be an argument in the court. So what the CSIR has done is they have put all these things to prove traditional that it's a traditional traditional wisdom was there. You put all this, they have archived, digitized everything, all this. Digitized entire Ayurvedic pharmacopoeia, that pharmacopoeia, traditional medicine knowledge, wherever it existed. They put this, and they said this is proof. This is now accepted, even in the American courts.
So you're talking about the traditional knowledge digital.
Yeah, I already did it. I have it because to prove that prior art exists, I have to show it in written form it exists. It existed as some paper much before this patent system came in. So they have digitized it. So that's one great thing CSIR did under Marshall. But still they'll have problems. I mean, it's not, they're not exactly.
I have two questions. One is why are Indian companies are losing many cases in foreign countries, and that is one of the main reason of selling of Renvaxi say to Daiichi Japan, because they have the Renvaxi a lot of litigation in the US and other countries. And second question is India ready for the Mission Impossible 3 scenario, the movie in which the it highlights the water can be the scenario, means spreading a new disease and then selling new drugs. Is India ready for that kind of scenario?
Second question I can answer easily. We're not ready because in the plague in Surat 1995. Remember the plague in Surat?
Yeah.
Surat. That plague in Surat, do you remember 1995? There's a lot of proof that it was planted. It was kind of biological warfare. They're testing the ground. I won't go into the details here, but I can tell you lunch. So we are not prepared. And any Tamiflu variant comes, of that swine flu variant comes, new variant comes, we don't have the drugs. Which anyway, most people don't. But we don't know whether it's part of biological warfare, we are testing ground, we don't. We only have suspicions. Like the only smallpox germ, bacilli is there only in Fort Knox in America. We have wiped out smallpox, but they have the last remaining this thing. They multiply to release it. It is a form of biological warfare. They may not do it, but they will do it. So we are not prepared for it. The first question was.
Why are Indian companies are losing many cases?
I don't know which company is which losing cases.
Red vaccine.
Red vaccine. I'll tell you about red vaccine. You go to the FDA, US FDA website. I've seen the letters. I've seen all the things. And I think, US FDA was right. You were given enough chances. See, you can't deliberately mislead. I am exporting to your country. Okay. I'm making it in India, but I'm exporting to your country. So I have to obey your laws. There's no question about it. The laws may be cruel, unjustified, etc. But I have no say as an Indian citizen over American laws. I have to obey the laws. The laws are reasonable. I'm not saying American laws are in every case stupid. In this case, it was reasonable. You're asking for it, and then you are exporting to my country, and also you are getting a US FDA GMP. So I come and inspect. When I come and inspect, I'm telling you these are the requirements. This is the basic thing. Then you hide or mislead me. All this is not to be done. I would think it's not. Glass particles are there, and I've told you these glass particles are there in the drug. Please correct it. But you're not correcting it. I've given you a long route to hang yourself. But they have not done it. And red vaccine hung itself. That's my opinion. I have no sympathies with. It's not an Indian company anyway. It's a Japanese company.
Yeah, right.
We should not even shed tears for it. Work hard. Work hard. You don't ask me about work hard.
Lots of litigation is the main reason of selling to Daiichi.
No. Litigation. Main reason selling to Daiichi is greed. And laziness of these young inheritors. That's my opinion. I don't have proof of what I'm saying. I'm very circumstantial proof. Because the inheritors is young kids, what's his name? Parminder Singh, Balwinder Singh and some other Singh. I don't know why work hard, I can get 1,700 crores, 2,000 crores. Maybe 7 पीढ़ियों में 7 generations I can live off this money. They didn't want to struggle, they didn't remember the struggle of their grandfather and father. It's all easy money. Same with Nicholas Perelman, easily 1,700 crores they got. So I said it off, easy money. And that's one thing. The other thing is,